Hello and welcome to this Narrow Quay HR webinar on collective consultation. My name's Sarah Martin and I'm an HR consultant with Narrow Quay HR. So we thought today it would be helpful to do a short session on collective consultation. And we're going to look at an overview of the law relating to collective consultation and also the obligations of employee representatives. The reason we thought this might be useful to cover is because a lot of our clients may have not dealt with this process before, or alternatively they have, but it's not been for a little while. So it's really designed as a bit of an overview, really, and to cover and to help you start thinking about the things that you would need to cover when you plan the process out. Why is it important to get this right? Well, there are draconian penalties for employers that don't follow the collective consultation obligations and are subject to claims in the employment tribunal. And those claims can be for up to 90 days gross pay for each dismissed employee. So where you've conducted a large-scale redundancy process and haven't got the process correct, it can be a big amount of money. And the other thing to say is that the tribunal will always start from the position of 90 days pay as the award, and then we'll work backwards depending on the defence that an employer can put forward. I suppose the other thing to say is that we can offer a much more comprehensive and detailed session on this subject for senior leadership teams or for a business's employee representatives. And I'd be really happy to provide some further information on that to listeners if they get in touch with us direct. What we found is in the case of employee representatives, they really appreciate being provided with training on their role. We've also found it helps the process run a lot more smoothly because there's a sort of understanding on the part of employers and the employee representatives about what their role is. And another thing we've been told is that it helps to send a sort of clear message that an organisation is committed to doing the process properly and fairly. So in terms of the first part, we're going to just briefly look at these things. What is a redundancy situation? What is collective consultation and how does that work? I'm going to touch on the interaction between individual and collective consultation. We'll think a little bit about who your employee reps will be, and then we'll touch on how notice and redundancy payments work. So for most of you, you will have an understanding about the sort of basic principles of a redundancy situation and when that arises. It's going to be in one of the circumstances set out on this slide. So perhaps a place of work has moved or disappeared, and we've seen that in the case of Dyson, for example, who moved their manufacturing operations abroad. It might be that the business is ceasing altogether, perhaps it's closing down. And we've seen that recently in the case of Flybe that was dramatically affected by the coronavirus outbreak and the restrictions on travel. Perhaps it's that fewer people are needed to do the same job, and that's generally often as a case of perhaps increased automation in a process that means that less people are required to achieve the same output. Or it might be that a business identifies cost savings are needed, perhaps due to losing a big client, a big order, or a change in demand for their services. I suppose the important things for an employer to stress in a process like this is that it's not about the individual. It's not a comment on their capability, their conduct, their performance in any way. It's a broader business issue. The other thing to flag is that these obligations might also arise where there isn't a redundancy as such, but an employer is planning to make changes to terms and conditions of employment. And that's not always obvious, I don't think, but in some circumstances where there are changes to terms and conditions proposed that might give rise to dismissals, collective consultation obligations might also arise. What does the law tell us about when collective consultation starts? Well, what we know is that it must begin in good time. Consultation must start in good time, and that means at least 30 days in advance of 20 to 99 redundancies within a 90-day period, and slightly longer, at least 45 days in advance of 100 plus redundancies within a 90-day period. When does that timescale come into effect? Well, the redundancies occur on the date that the first of the proposed dismissals take effect. So that is the date that you need to count back from if you are planning to make redundancies, large-scale redundancies. You need to have started your consultation process at least 30 days or 45 days before the date the first redundancy dismissal is due to take effect. So that might be after a period of notice. So when you're planning your process, you need to work out what those timescales will be and when you need to take various steps. And that might not be the same for each category of employee, depending on their notice requirement. In terms of what information you need to provide as part of the collective consultation. So thinking really about what requirements are on you as an employer in terms of the information you need to provide as a business to both the Secretary of State, which is a requirement to submit an HR1 form, and to the representatives who are representing the employees as part of the process. It is as follows, and it's outlined on this slide. So it will be the reasons for the redundancy proposal. So whether that be a lost order, closure of sites, the number and description of employees that are proposed to be dismissed. So, for example, it might be that it's not a whole workforce that's affected. It might be part of the workforce, and it might be a number of individuals within the same departments who carry out similar roles. So you need to just outline that. You need to set out total numbers. So if you're proposing to reduce workforce size by, say, 20 staff, you need to outline in this written information that is 20 out of a total of 60, for example. If it is a proportion of the workforce that is going to be selected for redundancy, you need to outline how you're proposing to choose between those members of staff. You need to explain how you're planning to carry out the dismissals, and you need to set out in writing how you will calculate redundancy payments that people will receive. Now, it's possible, of course, that there might be changes as the process unfolds, and ultimately that's part of the reason you consult, because you consult with a view to adapting your proposals depending on what comes out. So it may be that the information you provide needs to be updated as you go through. We've talked a little bit about the fact that there will be a consultation process, and in a few slides I will talk a little bit more about the meaning of this term consultation. But what are you really going to be consulting with people about? What's the process that you go through with your employee representatives going to cover? Well, broadly, you're going to be speaking to people about ways in which you might avoid the dismissals. So has anybody got any suggestions or proposals about ways that the dismissals can be avoided altogether? Or it might be that you're talking about ways in which the numbers can be reduced, and people might have ideas about ways in which you might be able to reduce numbers by, I don't know, stopping overtime, natural wastage, volunteers for redundancy, that sort of thing. And lastly, you'd be looking at ways to mitigate the consequences of dismissals. What does that mean? Well, that means things like looking at outplacement, assistance, thinking about redeployment for those staff that are affected. So I mentioned at the beginning that we would look at the relationship between individual and collective consultation. What collective consultation is really is an additional set of obligations an employer must adhere to if they're planning large-scale redundancies. But every redundancy situation will involve a level of consultation with employees about the proposal to make them redundant. And that individual process doesn't disappear just because you're in a collective consultation situation. So it's not a substitute for individual consultation. You will still have to do that as an employer. So as part of your planning and looking at the collective process, you will need to think about what procedure you will adopt in terms of that individual process. So usually what would happen is you'd go through a process of collective consultation, and there would then be some level of individual consultation with staff. And there will probably be an overlap between the sorts of issues you're talking about in collective and individual consultation, but it is important that you factor that in and think about how that will apply. You need to think about notice. So when an employee is dismissed by reason of a redundancy, they will be entitled to notice. So as part of planning a collective redundancy, you will need to have looked at what notice periods apply in respect to the employees who are affected. And that might vary. Often different types of employee, different descriptions of employee will have different notice periods. So when you're setting out your timeline, you will need to have gone through the contracts and have worked out who is entitled to what notice so that you can plan for when you would need to give those employees notice in order to do things by a certain date. If there isn't a notice period set out in the contract, or in any event, if you've got somebody whose notice period is shorter than the statutory minimum notice period, then the statutory minimum will apply. What is that? Well, it's 1 week per year for each year of service up to a maximum of 12. And the other point to bear in mind around notice is that an employee will be entitled to reasonable time off with pay after notice is served, so that they can look for other jobs, attend interviews, find alternative employment. Secondly, in addition to notice pay, any employee who's dismissed by reason of redundancy is entitled to a statutory redundancy payment, but they must have 2 years continuous service. Those employees that don't have that amount of service will be entitled to notice, but not a redundancy payment. The amount, how you work out someone's redundancy pay is based on their length of service, their age, and their pay, their gross weekly pay. But that pay is capped, and the figure is a statutory maximum. So if they earn more than the statutory maximum, then it will be capped. So up to a certain point. So that amount goes up each year, and it's just gone up on the 6th of April 2020 to £538 per week. So the easiest way to do this is to use the gov.uk redundancy ready reckoner, and using that you insert all of the details and it gives you a figure at the end. To give a couple of work examples, if an employee's weekly earnings are £300 gross and they're 28 and they've got 5 years complete service, their redundancy payment is going to be £1,500. If that employee earns £550 gross per week and they're 45 and they've got 11 years complete service, the redundancy payment would be quite a bit more. It would be £6,994. Be aware that you might have a contractual redundancy scheme as part of your policies and procedures. And if you've got that, you need to bear that in mind and use that. Okay, so we've talked a little bit about the legal overview, what a redundancy situation is, what collective consultation is, and what the financial entitlements are. In these last few slides, I'm going to focus a little bit more on the sort of practical part of the process in terms of what an employee representative's role is, the skills, and that part of it. I mentioned that I'd talk a little bit about what consultation is, because I think sometimes we found there can be a little bit of confusion. What consultation isn't is a flow, a one-way flow of information. It isn't an employer telling employee representatives what's going to happen, but nor is it a negotiation which requires a sort of agreement to be reached between the employer and the employee representatives about what's going to happen next and about the business proposals and whether or not they're acceptable. Consultation is very much a two-way thing. It's more of a sort of discussion, really. It's a debate, if you like. It's got to be genuine, and a really important thing for employers to bear in mind is that then they need to go into it with an open mind and with the view that the proposals they made at the outset might be modified as a result of the feedback. And I think it's really important for employers to sort of have that mindset as they go into a process, and that underpinning the sort of approach they take to it. What does that mean in practice? Well, to have a proper, fair consultation process, the employee representatives need to have enough information so that they can respond. They need to have enough time so that they can consider the proposals. The employer needs to really consider the responses and the feedback that they're getting and be able to demonstrate in their responses that they've done that. There needs to be a means by which the employee representatives can express the views of those they represent. So they need to have the means to be able to discuss things with those that they're talking to. But as I said, there's no obligation on an employer to accept a representative's proposals. So who are your reps? Who you appoint as employee representatives in a business will depend, and the legislation tells us who it should be. And it starts on the basis that if the employer recognises a trade union, then it should be that trade union. They will be appointed as the employee representatives. If you don't, then you need to look at what bodies you already have as an organisation. You might have a works council, you might already have a staff group, and if that staff group has authority, and you'll know that by looking at the terms of reference for that group when it was set up, hopefully you'll have something in writing. If the group has authority to be consulted with on collective consultations and redundancies, that's who you use. And if you're unsure about that, you'll need to check the position out. Otherwise, you'll need to go through an election process in order to specifically elect employee representatives for this specific purpose. So you need to find that out, because again, if you need to do an election, you need to factor that into your timeline. So what are the responsibilities of the employee representatives when they're going through this process? It's in a way, it's quite an important role. They're very much a sort of conduit of information that they need to manage the flow of information between the employer and the employees about what's happening. So in practice, that means they need to speak to their colleagues before consultation meetings. They need to have meetings with them. They need to perhaps receive information via email about what their views are on the proposals that have been put forward. They also need to go along to the consultation meetings, and they need to feed back to the employer what those colleague views are, any suggestions, any questions. Often there will be a lot of questions, particularly at the early stages. So they need to be able to do that. And in terms of that part of the role, planning around how they do that is going to be key. For some employee representatives, they will never have done anything like this before. So that's important. They need to pass the information back to their colleagues, and they need to be able to deal with those issues between the meetings, and have a method and a plan for doing that. What are the key skills? And we often go through this with employee reps when we're giving this training in a lot more detail, because I think they find it really helpful in terms of thinking about what it is that they need to do. Really important to remain neutral. Often it can be quite upsetting for everybody involved, in terms of the idea that they're going to be losing their jobs. Emotions can sometimes run high. So sort of thinking about remaining neutral and trying to sort of manage those emotions as much as possible. Effective questioning. So thinking about really understanding as employee representatives what the situation is, and getting clarification where there is uncertainty, to try and avoid misunderstandings. I think sometimes there can be a tendency to perhaps try and fill in some of the gaps, and when that happens, I think it can lead to confusion and misunderstandings. So thinking very much about using open questions and closed questions to try and drill down into the issues is quite important. Good communication and listening is always vital. Thinking about how those issues are presented, trying to put themselves in the other person's shoes, thinking about those listening skills in terms of really trying to listen to the information that they're being given. Sometimes we all do it. We're already preparing our response to a question or an answer before we've fully listened to it. So really trying to focus on that. And also trying to keep things focused in terms of not going off on different tangents, getting bogged down in issues that perhaps aren't as important as others. Focused on the agenda of the meeting, really thinking about, okay, my role here is to try and gather information, feed that back, and help those that I represent to understand the situation and get answers. And finally, just a sort of slide around employee representatives' rights, because there's sort of rights that go along with this in terms of entitlements and legal rights. So an employee representative shouldn't suffer a detriment for being a representative. So, for example, if a representative was to say, I felt that it was really frowned on that I did that, and I was overlooked for promotion as a consequence, that is potentially a claim for detriment there. Again, similarly, if they were to say that they felt or that they'd been dismissed for being a representative. An employee representative is entitled to paid time off to perform their functions or receive training. And if time is required, then we would just say that they should notify manager as far as possible, so that can be organised. They need access to a place to be able to undertake their duties. So perhaps they need a computer, a phone, Perhaps that needs to be in a confidential room so that they can get on and do that part of their job. Perhaps they need a bigger space so that they can speak to all of their constituents or those they represent. And that might be by means of a sort of, once a fortnight broad drop-in meeting, or more of a sort of open group meeting to discuss what's going on. So that's really all I wanted to cover today. As I say, we do a much longer session, which goes into some of these issues in more detail, in particularly looking at the role of an employee representative as it applies to those that are actually doing the role. But if you've got any queries, then please do get in touch. We'd be very happy to discuss. Many thanks.